Let's now turn it over to our instructor for today. She is from the Pompano Beach office, our main branch of Kaye Rembaum, one of the very few board certified specialists in condo and plan development law in the entire state of Florida. So we're privileged today to have Lisa with us. This is our resident rock star, Lisa Magill. Lisa, take it away.
Well, thank you so much, Jeff. And thank you everybody for attending today. Hope, just like Jeff said, I hope that you hope you had a wonderful holiday season and family with friends and a happy, healthy new year. And now everyone's back ready to get to the grindstone. I know you all community leaders have a whole lot to do on your plates for the upcoming year. So I'm going to go ahead and share my screen so we can talk about the legal update. When I was thinking about this legal update today, I was thinking about some of the other things that are not necessarily part of the legal update, but they are important from a day-to-day standpoint for you as board members and for you to be able to explain to your unit owners. So we're going to go through that. But basically what this does is update to you for the laws that were enacted in the 2025 legislative session. That's why in July, there'll be the legislative session, the laws will be enacted again, and we'll have a new cycle. And if you've been a community association leader for a long time, you know, these laws, they change constantly. They change constantly, and sometimes they change and then they change back, and then there are little tweaks. So for the most part, I'm hoping that it won't be very drastic changes for you. See how to navigate this. So the first thing I want to talk about are CAM license requirements and restrictions. I say the word CAM thinking everyone understands it, but really that means community association manager. In Florida, community association managers are licensed. Not only are the managers licensed, the individuals, but a community association management firm has its own license. And that's not universally consistent throughout the United States. There are actually a minority of states have license requirements for CAMs. I think it's an important thing. I think it's a good thing. And I think it establishes some at least baseline knowledge and accountability on the part of the people that are managing our communities. Now, none of the associations out there are required. The law doesn't require you to have a CAM. But if you're going to have anyone that performs CAM services, and we're not going to go into that today, but does your budget, does your meetings, handles association management, basically, then they do need to be licensed if you have a budget of over $100,000. So again, you can hire someone to perform bookkeeping services. They don't need to be licensees as a CAM. You can hire someone to perform office management services or secretarial services. They don't need to be licensees, but anyone that's going to perform CAM services needs to have a license. They need to keep their license active. So for this year, what changed is that if a CAM does have a revocation of their license, now the penalty is that they cannot own or work for a management company and cannot renew or obtain a new license for 10 years once the license is revoked. CAMs all have to have an account with the DBPR online, and the account has various information that is associated with it, but it also lists the communities that they serve. This parlays into something that is required on the part of the community association managers. I have the little box on the top corner of the screen that they have now. For HOAs last year, 2024, the law changed to require the CAM to attend one meeting in person on an annual basis. That's been converted over to the condo side as well. So if you do have a licensed CAM working for your association, then they do need to attend at least one meeting annually. And your owners are entitled to contact information for that community association manager. So there must be a way, you can list it on your website, the contact information for the community association manager that's responsible for your account. And of course, owners are entitled to a copy of the contract with either the community association manager, if you're working with an individual manager, or with the management company. That didn't change because, of course, your contracts are official records, and official records, for the most part, are available for inspection by the members. your contract with your management company or your manager has to contain specific professional standards language. If you're in the middle of a term right now, that doesn't necessarily mean that you have to go back and modify the contract that you're working under right now. But when you do renew, or if you do change providers, then of course the contract needs to comply with the requirements of the statute, and that includes the professional disclosure. Continuing on with the community association management relationship, the conflict of interest disclosures have been substantially strengthened in the last year. So the management company or your CAM must list all persons or entities with which they have a beneficial relationship. It has to be listed in the contract. So you have to list all the services or vendors or other professional services that may be involved in management of your association or operation of your association. If they have a beneficial relationship, it needs to be notified, and the members need to be advised of that as well. Now, if you have work that's going to be performed by one of these companies or entities that has a beneficial relationship with your manager or with your management company, then the management company or the CAM must receive competitive bids if the work to be performed is going to exceed $2,500. So that doesn't mean that it's a terrible thing that your CAM or your management company has relationships. You want them to have relationships in this industry. You want them to know that they have people that they feel are adequate to perform the work for their clients, and that they have this beneficial relationship going back and forth. But you as a board member need to be aware of that, and you as a board member need to have the ability to compare the services that would be rendered by that company to another company that would perform the same services. And if there is a presumption of a conflict, if the CAM or the management company proposes to perform services other than management services. So what kind of services? Landscaping services, design services, interior design to services, even services like recreational type services and the like. Now, all conflicts or potential conflicts need to be disclosed on the meeting agenda. So if you're going to be hiring a company with which the CAM or the management company has a beneficial relationship, that needs to be disclosed on the meeting agenda. It also needs to be disclosed on the contract itself. And if there is an undisclosed conflict, then your contract with that CAM or the management company is voidable. It doesn't mean that it's automatically canceled. It does mean that the association has the option to say, hey, you didn't tell us about this conflict. We just learned about it. We don't trust you right now anymore. So therefore, we're gonna void the contract, and you're only responsible to pay for the services that have been performed. You're not responsible to pay for early termination penalties or the like. When it comes to your management, though, the board likewise has obligations. So you can't just rely solely on the CAM to do everything. The board yourself have obligations. You have to verify that they are licensed. And that's very easy to do. You can just search into Google DBPR licensee search, and you can put in the name of the management company and the name of the individual CAM. If you're working with a community association manager or a management company, and that individual manager's license is suspended or revoked, the association can terminate the contract immediately upon receipt notice of the disciplinary action. So you're not stuck with that management company. You may have a 3-year contract, but if you do learn of the revocation, then at that point you are able to go over to another company. And then the same thing is true with your with your individual camp. So you want to ensure that you keep on top of the professional standards of the people with which you contract, to ensure that you, as the member of the board of directors, are operating your association legally. Because if their license is revoked and you're hiring that person to perform CAM services, then you're guilty or have utilized unlicensed contractors, and that's not a position that you would like to be with. Um, there's a question here actually, if the conflict of interest disclosure is appropriate if the CAM is providing services such as maintenance to individual unit owners. Now that's something as a board you want to talk about, whether or not you want to allow, not allow, and if you do allow, under what circumstances. You want to have some type of writing that memorializes the fact that the CAM is actually performing services to someone as an individual, not on behalf of the association. Why? Well, if they do something wrong, something happens, then automatically the association will be looked toward for liability purposes. And you want to make it clear, like, no, that was not work being performed on our behalf. That was work that you individually contracted for. And here is a copy of the contract. That's why you may want to require written contracts. You may want to have policies on place that actually delineate what services may or may not be performed by an individual CAM or a management company for the individual owners in your community. Again, I don't necessarily think it's a bad or a good thing. I just want everyone to know the nature of the relationships, because having even one of your employees is really very, very important. Even if you allow one of your employees to change light bulbs in somebody's unit on their own time, or fix someone's toilet, that is not work being performed in their capacity as an employee of the association or as part of the management contract. That is work that's being performed either as a courtesy. Maybe they say, oh, don't worry, I'll come over and change your light bulbs for you, or for some type of compensation. But that's an individual relationship. That's not your relationship. That's the association's relationship. That's the individual's relationship with the person that's providing those services. And I did have an issue with that one time long in the past, where one of my clients had their maintenance person would agree to check units when people were away for the winter months. But it wasn't clearly delineated. Everyone knew, I mean, people paid the individual maintenance person, whatever they wanted to compensate them for that service. But at the end of the day, something happened. There was a water problem in one of the units. Of course, the water spread from one unit down to the units below, and the association, at the end of the day, was found liable. Not that there was a judgment through a litigation and a trial, but of course there was a application to the insurance policy, and the insurance company wound up settling the case. Now, here's the next thing that I want to talk about. This is probably one of the most important things, and this is video conference meetings. Since COVID, many people have been conducting their meetings via video conference, just like this. Today, we're using a Zoom platform today. There's all kinds of different platforms out there. It's been very, very convenient. I find it fabulous because there's been increased participation as a result of the video conference meetings. It's been more convenient, and you have better notice to your owners of what's going on in the operation. The law changed this year to say that if you're going to conduct those meetings via video conference, you have to record the meetings and you have to preserve those recordings for a year. So this is different, or unlike that when you audio record a meeting solely for the purpose of creating the minutes. Because if you audio record the meeting solely for the purpose of creating the minutes, once the minutes are drafted or approved, you can destroy the recording, and the recording is no longer official record. This is different. The video recording, of course, with audio, is an official record. It has to be maintained for a year, and it has to be posted on your website, or a link to it posted on your website. Another issue about video conference meetings, the annual membership meeting. This is a very, very quirky provision in the law. If you're going to have your annual membership meeting held via video conference, this is different from electronic voting, but via video conference, then the law now says you need a quorum of your board members physically present, where the meeting is taking place. So you can't have an annual membership meeting solely remotely. There has to be a physical place where people can go to participate in the meeting, and a quorum of your board members have to be physically there. And that likewise, all of the different types of meetings, including committee meetings, need to be recorded if they're conducted in a remote platform, and maintained on your website or preserved for a year. I have a little note over here saying unit owners are permitted to vote electronically after a petition. I'm going to talk about that in a little bit, when I start talking about voting. Official records and website requirements. So minutes are maintained indefinitely. In the past, they were maintained for, well, in the past it was 7 years, and then it was 10 years, and now it's indefinitely. So if you don't have minutes more than 10 years old, well, obviously you're not liable for that because you weren't required to have those minutes more than 10 years before 2025. Now make sure that you maintain those minutes indefinitely. And what I suggest is that you include the notice of the meeting, the affidavit of mailing, if it's a meeting where an affidavit is required, and the minutes all together in either in a single file or in a place where they're all readily accessible, because we do need those notices of meetings and those affidavits of mailings for certain purposes, particularly when it comes to collection. So if we need the affidavit of mailing to reflect that you did a proper notice of the budget meeting, so that in order to collect regular assessments, we need the notice of the meeting and the affidavit of mailing to verify that notice was given of the special assessment meeting if we're trying to collect a special assessment. And of course, if there's any investigation by the division, you're going to have to produce those notices and those affidavits of mailing in connection with any of the other requirements for affidavits. Not all of you probably are in compliance with this, but the statute does say that you have to have copies of the governing documents, the Q&A sheet, the most recent year-end financial statement, and the budget readily available. So what's contemplated by the statute is that you have an office, and in the office you have, 5 or 10 sets of these in case somebody walks in one day and says, hey, can I have this record? And you can go over and say, oh, it's right here. I'll give it to you right now. Not all of you have offices or have a way to preserve or have it readily available in that way. If you can just immediately print something for someone, or most of this information is going to be on your website, you can go ahead and print it right from your website and deliver it to somebody immediately. That should be considered compliance for this. For the smaller communities out there, I know those of you with 150 or more units have had your website in place for several years now, but those of you with 25 or more units are required to have the website. It's already supposed to be up. Everything is already supposed to be loaded up into the website by January 1 of this year. So if you haven't done it, please make sure you get on that right away. And please make sure that you go through the list of the documents that are required to be posted and ensure that your website is compliant. In the cases that I've had over the last few months, several months, maybe up to a year, the first thing that the division does when they receive a complaint regarding lack of access to records or something wrong with the website, the first thing they do is they call the manager, they call one of the members of the board of directors and say, okay, what's the URL for your website? Give me a password because I want to go on your website and do a snapshot to see if you have everything that is posted. So that's really important. And there are various companies that do this for you. And of course, you need to upload things within certain periods of time. Actually, I have it right here. You must post documents to the website within 30 days of the creation or of the record. So if it's a new contract, it has to be up on the website, or at least a list of that contract up on the website within 30 days, when you receive your financial statements, after you adopt your budget, and any of your insurance policies, all the other things that you have posted there. Of course, meeting notices still need to be posted in advance, whatever the time requirement is for the meeting notice. And if you're voting on a document at a meeting, then the documents to be voted on need to be posted up to 7 days in advance. The statute always talks about you need to post affidavits. It says all affidavits required by this chapter, which is chapter 718 of the Florida statutes. So what affidavits are required? Well, we already know the affidavits of mailing are required, but I had to do a search to figure out what other affidavits are required to be maintained as official records. So confirming distribution of the financial report. Once you get the financial report and you send it out to everybody, you have to have an affidavit on file saying, I, Lisa Magill, sent out the financial report on January 8th. Same thing is true with acknowledging receipt of the completed structural integrity reserve study. When you're doing collections, now you have the notice of late assessment letters, notice of late assessment affidavits. Those need to be posted, not necessarily the letter, but the affidavit needs to be posted. And we're going to talk about this again when we talk about voting, but there's an affidavit that someone checked the email address that's been designated for the receipt of emailed ballots. When I talk about emailed ballots, that's different than electronic voting. So let me go back to that for 1 second, because we've talked about the difference between electronic voting and video conference or electronic voting and video conference meetings. If you're conducting a vote electronically, that doesn't necessarily mean that you're conducting the meeting remotely, because you may have just a regular date, time, and place where people arrive for the meeting, and all your votes are submitted, or the votes of the people that elected to vote electronically are submitted through the online platform. That is not a meeting that must be recorded and must be posted on your website. But if you do have a meeting where there is a video component to it, then you have to post it on your website and you have to maintain those recordings. So the lot talks about criminal penalties when it comes to failure to provide access to records, or with regard to election fraud. I don't want those board members to be overly concerned, because if you're doing the best that you can, then you should not be concerned about facing any criminal allegations of criminal conduct or criminal penalties. There are situations where people purposely refuse to provide access to records, especially when they're trying to conceal wrongdoing. So if their violations are committed willfully, knowingly, and intentionally, then you can trigger criminal sanctions if it's repeated. With respect to the financial reports, your CPAs can breathe a little bit of a sigh of relief, because now the deadline for providing the financial reports to owners has been extended from 120 days to 180 days. And you can send out the reports any way that the members so desire. I put fax on here. I can't imagine that you'd be faxing to 150 different fax numbers, but many of you are now using email for official notices. I think email is great for official notices. So if you can do the distribution via email, just make sure that you have that affidavit on file. And you still can reduce your level of financial reporting. So if your income level requires an audit, you can have a membership vote to reduce that audit down to a compilation or down to a review. But remember, that's only for 1 year. And the next year, you can't waive or reduce it. So it's an every other year thing. So if your income is over $500,000, you may do an audit in year 1. In year 2, you may have your members vote to waive the audit and only produce a review or a compilation. But then the next year, you have to commission an audit and distribute an audit to your members. And under those circumstances, you may just want to talk to your CPA, because since there's going to be a gap in years and they may have to do additional work in the previous year that wasn't audited, it may be financially not beneficial to you to skip the audit every other year. The vote to reduce the level of financial reporting has been increased. It used to be a majority of the quorum. Now it's a majority of the total voting interest. And this is the same vote now to waive the non-SERS reserves. It's a majority of the total voting interest. So if you have 100 owners, That means you have to have 51 voting in favor to either reduce your financial reporting or to vote to waive your non-SERS funds. There's been some changes when it comes to the budget meeting requirement. Of course, if you hold your budget meeting via video conference, again, you have to record the video conference and you have to preserve the recording and post it on your website. In the past, there was something in the law called the 115% rule. And there's still a 100% rule. The rule is a little bit different than it was before. In the past, if your budget went over or was more than 15% higher than the previous year, then the members could petition the board to adopt an alternative budget. There was a lower budget. Now, if the budget goes over, is more than 15% than the previous year, more than 15% higher than the previous year, then the board has to submit simultaneously a budget without, quote, discretionary expenditures. I put that in quotes because that's exactly what it says in the statute. And I know, well, none of my clients include expenditures that they're not necessary in their budgets. Most of you are as close to the vest as humanly possible, because nobody wants to pay more than they need to pay. Now, are there in some cases, discretionary expenditures? Sure. Some associations have social expenditures. Some associations, may have, replacement of furniture or redecorating expenditures that may not, quote, be absolutely necessary at the time. But most of you, it's just not the case. If the budget goes up by 15%, that's because your expenses went up by 15%. When you're calculating this 15%, though, it does not include reserves. Reserve budget does not account for that 15%. We're only talking about the operating side of the budget, and it does not include insurance premium increases. Insurance premiums were a major issue in the last several years. Now I think we're seeing a little bit more relief. Again, the alternative budget is provided at least 14 days prior to the budget meeting, just like the regular budget. And it requires a majority of the entire membership to vote in favor of the substitute budget for the substitute budget to rule over the budget that's proposed and adopted by the board of directors. In my experience, in the past, when we had petitions to adopt an alternative budget, I've several times held petitions, held the meetings. Never in my experience, and I've been doing this for quite a long time, has an alternative budget actually become the effective budget of the association. Either there's just not enough support, or people ultimately realize that the expenses are what they are, and the board members are not increasing the expenses voluntarily because they, just like everyone else, have to pay what the maintenance fees that are derived from the budget. So just a little other couple of tidbits about the budget. Of course, it must be adopted 14 days prior to the fiscal year. If you don't adopt the budget in time, your previous budget goes into effect until your new budget is adopted. Multi-condo is where you have one association that's operating several condominiums within the association. They're required to maintain separate budgets, and that's in effect, except for communities that were prior to 1970, 77, I believe, 79 or something, that voted to consolidate their financial operations. And lately, I've been seeing a lot of questions about the rollover of surplus funds. If you have additional funds remaining in your budget, consult with your CPA as to whether or not you need a board or a membership vote. It's really just a tax issue, and most of the communities that I work with, it's not an issue whatsoever. I also had a lot of questions recently about surplus funds from special assessments. When you have a special assessment and there are surplus funds, after you've completed everything that was announced in the special assessment notice, so you adopted a special assessment for a reason, and the purposes for that special assessment were listed in the notice of the meeting. If once you complete all that stuff, you have money left over, that's wonderful. The statute says you either have to return that money or use it as a credit against future assessments. What does that mean? Well, that means that the board, via board vote, you don't need a membership vote, can determine to take the excess funds in that account and put it into the operating account. And that's going to reduce what's necessary to be budgeted in the future year or for that year. So it does act as a credit towards assessments. And depending on what your financial circumstances are, you may even have the ability to move some of that money once it gets into your operating account into your reserve account and to reduce your reserve funding requirements. Either way, it operates as a credit against assessments. Very, very rarely in my experience has the association ever issued a refund. It's just more administrative work on your part. Now, it depends on whatever the political nature of what's going on in your community. But again, the owners are going to pay one way or the other. So you're either going to use it for expenses so that you can keep your budget lower or keep your reserve contributions lower. Or if you return it, you may have to reassess for that same exact money in the future. So here's what I'm going to talk about: electronic voting versus email ballots. Electronic voting is great, in my opinion. Anyway, it increases participation. It's so easy. People can just, a lot of times there's applications on the phone. They can just press yes or no, and they can vote from anywhere. They're on a cruise somewhere in the South Pacific or in their home in another part of the world. They can go ahead and vote. It makes life a lot easier. When we talk about electronic voting, we're not talking about people just emailing you their vote. The electronic voting platform has to comply with certain requirements. There's certain privacy requirements. Of course, in connection with the election of directors, the platform must be able to record how everyone voted, but no one on the board or no one in management are able to see how anyone can vote, because that vote is maintain the secrecy of that vote. And there are certain other obligations associated with the platform itself. If you have not adopted electronic voting, now the owners can petition the board to adopt an electronic voting system. The petition must be served within 180 days of the annual meeting, within 6 months of the annual meeting. So that gives you, so if you receive a petition, that gives you time to go ahead, take some demos of the electronic voting platforms, figure out which vendor you would like to use, and then you can go ahead and have your meeting for the board to implement and sign a contract with an electronic voting vendor or electronic voting provider. The board has to have that meeting within 21 days of receipt of the petition, so you don't have a whole lot of time in order to make your decision as to which platform you want to use. But within 21 days should be plenty of time just to attend a couple of demos and figure out which is going to be the easiest and most cost-effective for you. If you don't have electronic voting and nobody has petitioned for electronic voting, owners now can vote by emailing you their ballots. Now, when you email a ballot, you eliminate all the secrecy of the ballot, because the ballot is going to be emailed to the association, and there's no double envelope system and the like. There's no other privacy way to maintain the privacy of the vote. So email ballots have to contain certain information, including the name of the unit owner, which can serve as a signature of the unit owner, of course, the unit that they're voting for, and certain mandatory language that's outlined in the statute that advises the owners that they, or has the owners acknowledge that they're eliminating the secrecy of their ballot. Everyone's going to know how they voted. Their name is going to be on their ballot for the election of directors. For other types of votes, maybe it's not that big of a deal, because on proxies, again, are not secret votes. For the association side, you have to designate an email address to send those ballots. So you can use your regular management address, or just create a new address for people to email their ballots. And that's one of the obligations for affidavits. Somebody has got to verify, check that email address immediately prior to the annual meeting or the meeting for which the vote is submitted to determine if there are votes there so that they can go ahead and print those votes and you can collect those votes. So now you have to designate that email address for people to send their email ballots. Something about using email. Email is great for notice purposes. I think it's fabulous. What people sometimes don't realize is that if they give you consent to use email as their official address for notice purposes, that email address becomes part of the association's roster and therefore is accessible to others. People may not know that. I know that I've been questioned by some clients saying, well, my owners didn't know that their email would become public just because they consented to email notice. And there's two different kinds of use of email in a community association. Sometimes you'll have the email solely as a secondary method of contact or for courtesy information, newsletters or notices of parties or, alternative side of the street parking or things that are going on in the neighborhood. Those aren't official notices. But if you do have the email for purposes of sending the notice of the annual meeting, notice of the budget meeting, distribution of the annual financial report, and those types of items, those are official addresses and they do become part of the roster. They do become accessible to other members. So when you go out to ask people for consent to use email for official notice purposes, you may want to say, hey, listen, do you want to create a new email solely for association reasons? So if people do obtain your email address, you won't be bombarded or you won't need to have to look at all the emails that talk about all the gossip or whatever's going on in the community that you just may not want to be involved in. There's a question here. I completely agree with this question. All of our board members are remote, so we use Zoom meetings. What's the logic requiring a quorum to be on site? I really don't know the logic. I would predict that would be changed at some point, maybe not this upcoming session, but at some point people will realize, hey, if you're working remotely, why can't everyone work remotely? Why is the option to attend and participate remotely only given to a minority of the members of the board of directors when it comes to the annual meeting? I really think that's going to change at some point. But it's a really good question. And
They always tend to be, the division tends to be reactive and not proactive. I think that's part of the problem. But anyway, back to you.
Exactly. Well, the legislators are the ones that are making these laws, and sometimes they don't necessarily live in community associations. They don't necessarily work with community association managers. So the actual operations on a day-to-day basis, may not be completely understood. And that's why the law changes all the time. I mean, that's why things go in and then they go out and then they go in and then they go out. So a lot of it is trial and error. And to the extent that you can, you ensure that you participate in that process by understanding what's going on in Tallahassee. Oh, here, I give you a little bit more information about the electronic voting, only because I'm such a big fan of it. I just think it's so easy. You choose your vendor. When you decide which vendor you're going to choose, then you adopt a resolution that explains how people opt in, how they opt out, whether they need to register, how they get a password, all that other stuff. And when I talked about the requirements of the voting platform, then it says that they have to be able to authenticate the unit owner identity, authenticate the validity of the vote, furnish a receipt for the vote, store the votes for recount purposes, and then the most important, I think, is the ability to separate the vote from the identity of the voter when it comes to the election of directors. The law did change, I don't know if it was last year or the year before, that says once you start electronic voting, then you kind of have to continue electronic voting. Well, you do have to continue electronic voting, at least for the election of directors, unless people decide to opt out or just are over it. They don't want to vote electronically anymore. So, but that doesn't preclude you from Well, that does not preclude you from changing vendors. So if you like the vendor, you stay with the vendor that you're working with. If you have experience with the vendor, then you don't want to make a change, you can make a change anytime. You just adopt a new resolution, giving people the procedures of how they opt in and how they opt out. So there's a comment here that many associations are no longer using video due to have to keep the recording for a year. They're afraid of liabilities. It's sad in a way because you want the increased participation, but by having the meeting recorded and that recording preserved, and even though you're only preserving it as an association for 1 year or maintaining it on your website for 1 year. Once it's preserved, it's preserved. So it could be around 10, 15 years from now. It gives you a little bit more of well, it makes you want your members to control their decorum at the meetings better. And the comment here is they're afraid of liabilities. Well, that's one of the reasons why we talk about when you create minutes of meetings, and if you're audio recording your meetings, only to audio record them for the purpose of creating the minutes, because things are said at meetings that are not necessarily very favorable to the association or put the association in a favorable light. And the example that I have where it does or it has become problematic is in the case where you have insurance claims. And this is only from my experience, because back in the 2004, 2005 years, we had a ton of hurricanes. Remember, we had 4 hurricanes in 1 year and then 3 or 4 in the following year. And the west coast of Florida, of course, got eviscerated. And then we on the east coast of Florida really had some major, major problems as well. So what the insurance carriers decided to do is conduct record inspections, which of course conduct discovery, ask for all the minutes of all the meetings from the beginning of time to the extent that they were available, and any other record that they could get their hand of. And there would be comments say windows are leaking, or you haven't done this and you haven't fixed that, and the roof has been leaking for blah blah blah, and the windows are leaking. And the insurance companies would use that information to say, hey, listen, that's a problem that you had with the window from prior to the storm. People have been complaining about it for 5 years. You can now not say that all of your window problems or all of your roof problems or whatever it was solely due to the storm, because we have the evidence here. But today's day and world, and that was back in 2004, 2005. So today's day and world, the vitriol is just so intense that there are other issues that I fear could be problematic that come from these meetings when they're recorded and the recordings are preserved. But on the same time, I don't want to discourage people from encouraging more participation. I don't want to discourage my clients from having more participation at their meetings. I don't want to discourage the clients themselves from enabling their unit owners to participate when maybe they're at work, maybe they can't get home in time for a meeting, maybe, or they're away or they're at their other location. So that's something that you'll need to think about for yourselves to determine whether it's important for you or not. Again, that I can't predict as to whether or not there'll be any changes. So the milestone inspection updates. Hopefully everybody that's required to have one has already had their milestone inspection, and hopefully you've already either completed your repairs or are in the process of completing your repairs. But every year there's going to be new communities that are going to be up for their milestone inspections. So these changes are very, very important. They're based upon a lot of complaints that were made to the legislature about some of the shenanigans or in certain areas that occurred, or at least that were alleged to have occurred in the past. The height requirement changed. It's always 3 stories. Now it's defined as really 3 habitable stories. So the 2-story condo over the parking garage is now exempt from, or the parking spaces is now exempt from having to perform a milestone inspection. If you did it, more power to you, because now you know if there was any problems with the building, or maybe everything was great, but if there were problems, you found out about them, you got them taken care of. Going forward, even for your two-story condos out there or one-story condos out there, I would never discourage you from hiring an engineer to come and perform an inspection so that you have the self confidence that your building is in good shape, and to create a maintenance plan or future capital improvement plan, so that you can yourself know what's coming down the pike and what really needs to be attended to. But the issues that were most concerning among the members of the legislature are the relationships between the person or entity conducting the inspection and the person or entity conducting the repairs. So if you use a milestone provider, engineer, or architect that isn't connected with a construction company or part of a construction company or a relationship with the construction company, that they need to disclose that in advance and disclose whether or not they intend to bid on the repair work. Intent to bid, again, you're the board, you're going to decide who you want to use for the actual repair work. Your contract with the inspector to perform the milestone is going to be completely separate and apart from your contract with the contractor to actually do the work. But again, so that needs to be disclosed. So right at the outset, you have to know, hey, is the person that we're hiring or entity that we're hiring to conduct the inspection a person or entity that's going to want to do the work at the back end. And the same thing is true on the back end for the bidders, although you would expect to have that information known already. But when you actually bid for the project, if those bidders have a relationship with the company that prepared the inspection, they have to disclose that relationship, and it has to be included on the contract. And there's a lot of statistical reporting because the local enforcement agencies have to assemble and furnish the DBR with a whole bunch of information about these milestone inspections. You know, how many have been performed, how many communities complied, how many communities are not in compliance, whether there was a phase 2 report that was required as a result of the inspection, what the value of the permits were for the repair work, and the like. There's a whole lot of information they want to assemble to evaluate the status of what's going on with our communities out there. So milestone inspections and reserves are somewhat related, but they're not 100% related. You know, your milestone inspection is to determine what the existing conditions are of the building, to determine whether there are any safety concerns, and to develop a protocol for repair to bring the building into its optimal functioning performance. So it's to bring the building into compliance with whatever it needs to be in compliance with in order to make sure that it's a safe environment. And that's for on the structural side and on the electrical side. Reserves and SERS funding is a whole different concept. Really, that the reserve concept is to determine all of your components, whether they're structural or non-structural, and to give you a roadmap of when things need to either be replaced or substantially repaired. And the funding methods, so the SERS, you know, are mandatory funding now. There's no way to eliminate your funding other than the pause that we're going to talk about in a second for the structural integrity reserves. But for your non-structural integrity reserves, then they still can be waived by the members with a membership vote. The law was modified to clarify that you can fund the reserves through regular assessments, which is quote the normal way, or via special assessment, loan, or line of credit. But if you're going to use, I call it alternative funding, it's not really alternative funding, but if you're going to fund it in any other way other than through your periodic payments of annual operating maintenance assessments, whether you pay monthly or quarterly. So if you're going to use a special assessment to fund it, if you're going to use loan or line of credit, you do need to obtain the approval, a membership vote, and that's a majority of all voting interests. Another clarification, or actually modification of the law from 2025 is pooling. Pooling has been allowed for many years. I think it's close to 10 years at this point, maybe even more than 10 years. But in order to change from straight line funding to pooled funding, you had to have a vote. Why? Because if you had something in the roof reserve and you want to put it in the pool for SERS funding, well, then you're changing the use of that roof money, because that roof money is now going to be available for use for any of the SERS components. So the legislature said, okay, pooling is a better method for SERS purposes, or we recognize that it's a better method for SERS purposes. So we're not going to require a vote for any of the community associations to pool their SERS reserves. So if you have money in SERS straight out on reserves, at this point you can just move it into a pool or start a pool for the SERS reserves. It's not the same thing with your non-SERS reserve because they didn't change that law. So if you have money in straight line categories for pavement or redecorating or um, lobby furniture or what have you. I mean, there's all kinds of more important things. Elevators, in fact, elevators are not SERS components. Then at that point, you need to have a membership vote to move that money into a pool if you wanted to start pooling your non-SERS. And it's important that you have to have your SERS pool and your non-SERS pool completely separate. So your SERS items are all going to be in one pool, and that's a specific list of items that are in the statute, and your non-SERS items are going to be in another pool. And the reason being that non-SERS, you can waive funding of non-SERS reserves, and you can also move non-SERS reserves around. You can obtain a loan for SERS or capital expenditures. There's a question as to whether or not the statute would override your existing condominium documents. So before you go out and get a loan for anything or sign commitment letters to obtain a loan for either a line of credit or for reserves or for a capital expenditure, just go ahead and check with your counsel, because that's something that's important for you to know beforehand. And the SERS funding can be paused if the building is considered uninhabitable. That's if there's a natural disaster, or for 2 years prior to 2028, so if you're working on your milestone repair. So if you have your milestone today, 2026, and your milestone includes concrete restoration and includes roofing, and those are big line items, and your SERS would, of course, say that needs 100% funding because you need to do it this year. Well, you can pause funding for future reserves to put that money directly into the project. So you're going to be paying for concrete restoration. You don't have to reserve for concrete restoration at that point. You're paying for the roof right now. You don't have to reserve for a new roof. Once you finish the project, then you have to resume SERS reserve funding, but your schedule is going to change. You're going to have your reserve provider recalculate everything based upon the newness of the components, and then you'll have a much longer life to fund those items. I don't know if it's going to change for the 2018, so we don't know, because right now you should be funding everything that's in your SERS. So hopefully by 2028, as it said, you'll have enough money that it won't be necessary to pause your funding. And everyone talked about, what does full funding mean? What does full funding mean? Well, now it's defined. Full funding really means what we call baseline funding. And baseline funding means that your reserves never get below zero. So you'll talk to your reserve provider, because that's who understands this concept inside and out. And they'll give you various options or various recommendations for what reserve schedule to put into effect, but they all know that it can't be anything other than baseline funding. Many other reserve providers are going to recommend something more than baseline funding, but again, that just depends on your circumstances and your financial wherewithal. The SERS and the non-SERS items must be listed separately in the study, and you're only required to reserve now for items where the cost of repair or replacement is $25,000. In the past, it was always $10,000. So if you took a look at some of these reserve reports, you could have 50 pages worth of of a report and all different items that were 11, 12, 15,000, 17,000, 50,000, 17,000. You can drop those off your reserve schedule and concentrate on anything that's over $25,000 or more. And that number is going to be adjusted for inflation going forward. So let's talk about money in reserves. So before I talked about if you have surplus funds in your you have overage funds, surplus funds from a budget surplus from year 1 to year 2, or you have surplus funds in your special assessment accounts. Well, it's a great idea if you have the ability to put some of that money into your reserve. But that changes your whole reserve schedule now, because remember, your reserve schedule is based upon a starting and an ending point for each year of the schedule. And now that you're changing what money is on the front side of the report, then you're going to change, the numbers are going to change. So you have to go back to your reserve provider and either have them recalculate the numbers based upon the existing reserve study component with the component lifetime, the estimated remaining life associated with the component, and with the estimating cost of replacement or the estimated repair cost at that time. So you can either have a base calculation modification. Most of the reserve providers will recommend a reserve without inspection. It's an update, where they do actually go through the work of determining whether or not their calculations or their estimates for the future funding is appropriate, or whether they need to adjust those amounts for the actual cost of the component repair or component replacement. And then they can also adjust, whether the interest that you may accrue on your account or inflation as well. And then again, the reserve providers also need to disclose whether or not they will bid on work that's performed in accordance with the structural integrity report. And the same thing is true that if there's a beneficial relationship between the entity that's going to perform work and the provider of the reserve study, that it needs to be disclosed in writing and included in the contract. And those contracts are voidable in the absence of the required disclosures. How are we doing on time, Jeff? We okay? Might not be there. Okay, so investment of reserves funds. This was something that's been bantered around a lot. It really hasn't changed much, but there were very complicated proposals to address handling of all this money that you're now going to have in reserve, because maybe just stacking CDs may not be a good option any longer, especially if you have 5, 10 more $1 million in the bank. So the statute now recognizes that you can use a combination of certificates of deposit without requiring any vote of the owners, and also recognizes that you could use different types of financial institutions. But here again, I'm going to warn you, take a look at your governing documents, because a lot of the older the governing documents will say has to be an FDIC insured facility in Florida, or a Florida financial institution, or have some other kind of relationship. Some kind of restriction. So now, if you want to use any of these other types of financial institutions, including, the Morgan Stanley or other types of brokerage accounts, just make sure that you confirm in your governing documents through your counsel that is suitable for you. And if not, then go ahead and amend your documents so that you could take advantage of some of the financial options that will be available to you. There's no vote associated with making investment decisions, although you do want to report on those investment decisions at a minimum, in my opinion, on a quarterly basis. Okay, so there's a question here that I get every single time I do one of these, and there's a difference of opinion in the legal community. In fact, even in my own law firm, there's a difference of opinion. It says, what constitutes a board meeting? In other words, can board members get together to strategize without making decision and not post and record? What constitutes a board meeting? Well, the administrative code says, anytime a quorum of the board gathers together, and that includes remotely via video or via phone for that matter to discuss or to conduct association business. Now, conduct association business has never been defined in any case law or any administrative ruling from the DBPR as far as I'm aware. So there are attorneys that say if you're not making motions and you're not making any decisions, you're just talking about what you're going to plan for the following week or the following month or what have you, then that's not conducting business. And therefore, you don't need to notice it and you don't need to record it and you don't need to invite the other members to attend and participate. I'm actually I'm more conservative on this because I think if you owned a business and you were talking with one of your employees about whether or not you need to order more office supplies, whether or not you need to update your computers, whether or not, one of these employees are working out or not, I mean, to me, that's conducting business. You're not doing it for fun. You're doing it for a reason. And the reason is associated with the business. So again, go to your counsel, get a legal opinion for yourselves on this issue. Because I'm much more conservative maybe than others. And I'll readily admit that. So account registration and resources, I really should have taken this out because it was all due by October 1 of last year. If you haven't done it, you're going to get this presentation, and I have the links, I think, in the following. Do I have the links in this one? I mean, maybe not, but you have that email address right there, the CTMHE Education. You can always contact them and find out, do we have everything that we need? They were great about publishing instructions for how to find your management ID and how to find out what your license number is and what you needed to put in there, and make sure, and if you haven't done it, or if you're taking over a new community, if you're a management, just make sure that they've done it and they've done the right things and they've uploaded everything that they're supposed to upload. It's going to take a long time for the DBPR to be able to sort through all that information. And I can't imagine there will be enforcement on its own just by culling through the information that's actually on the system, the platform.
Lisa, I'm pretty sure it's on the last page of the presentation. The links.
Okay, good. So when you do receive, so when you do receive the this outline, you're going to have all the links that you need, and they did provide a whole lot of information. There's a couple other items that were not part of the required education for the board member update, but I do include it in here, and it's flood disclosures. And the reason that I include it, it's not you as a member of the board of directors or you as a management agent that are required to initiate these flood disclosures, but you as a seller of a property. So if you're going to sell your property, whether it's a condo unit, whether it's an individual home, you must provide a flood disclosure, and it's very, very important, because if you fail to tell people that there was a flood and fail to provide evidence that the work that was required to be performed to repair all the flood damage was performed, then you're jeopardizing that new owner's ability to be able to maintain a flood claim in connection with a future flood. So you don't want to be in that position. There's already a lawsuit here. We didn't really talk about it this year because it hasn't changed, but you have to disclose assessments on the estoppel certificates. There's already a lawsuit that's filed right here in Palm Beach County where someone did not disclose that there was going to be an assessment for an elevator or some other type of work. And the assessment was levied by the board of directors like within 3 months of these purchasers' acquisition of title, and then they sued their sellers for the failure to disclose. And it was actually a pretty significant assessment. So make sure that you disclose everything. Disclose. You're never going to be accused of over disclosing anything. On the pilot program, again, that ship has sailed because all the funds that were allocated to the program have been committed, but there were changes to the program. And so be on the lookout, or be on the, for this year, for the upcoming year, for the 2026 year, because the board itself has the ability to apply for funding for the inspection. That's the mitigation inspection. And then in the event after the inspection, the association desires to apply for mitigation funds to actually perform the work. Now you only need a 75% membership approval as opposed to 100% membership approval. So as a board, you have the ability to go ahead and vote and authorize application for the inspection, the mitigation inspection. Once you get your mitigation inspection, then you're going to go back to your members and ask for membership approval to apply for the mitigation funds. And here are all those links that I told you about. So creating on the online account, looking up your managing entity number, your association information, and all that other good stuff. So we do have a few more minutes, I think. So I can start taking a look at some of the questions here because I haven't really done a whole lot of that.
And while Lisa's doing that, I'm just going to interrupt real briefly. If you haven't already done so, folks, please enable or click on your chat button so the chat area appears on your screen. If you haven't already done that, you're not going to see the link we placed for the evaluation. So do that now if you haven't already done it, and I'll put the link in there once again. After you click the link and fill out your evaluation and submit it, the required part is over and you can exit if you choose to exit. But if you do, you'll miss a few of the Q&A aspects that Lisa's about to go over. Lisa, back to you.
Thank you. Thank you. So here's a question I get every single time that I do one of these presentations. If you have a meeting, an audio meeting, and you allow your owners to participate via audio, does that count as a video conference that must be recorded? The answer is no. So if you're doing it via telephone conference, or you can use the Zoom function without any audio component, it's just an audio, then you don't need to record the meeting, you don't need to preserve the recording or post it on your website. However, for participation purposes, meaning attendance purposes, I find it far more difficult for you unless you collect proxies from the owners that are participating remotely for them to be included in the tally of members that are participating, and especially if you're taking any votes, because audio votes are a little bit more difficult than video recorded votes. Is it legal, some conflict issues? Are there any issues between a board member beneficial relationship with a service provider or a contractor? Yes, there are conflict of interest disclosures required for individual board members as well. Any person or entity with the board member has a beneficial relationship must be disclosed. It has to be disclosed to the board, has to be disclosed to the owners, has to be listed on the notice of meeting where the board is voting to vote to engage that contractor or service provider. And it has to be included in the contract itself. So there's a bunch of different disclosures. Again, you may, one of your board members may work for a contractor, may own a contracting company, may own a painting company. I always give this example. I have a community, a very, very beloved community where the manager was there for 15, 20 years, really long time. And her husband was a painting contractor. And every 7 years, they would go get bids for painting. And every time he was asked to bid and they chose him regardless of whether or not he was the lowest bidder. Why? Because they knew that their manager had total control over what was going to be happening with that contractor and those contractors' employees. So they left one paint can out, or they did one thing that they weren't supposed to do. Boom, boom, immediately everybody was back on site, making sure everything was done right. So it doesn't necessarily it's not necessarily a bad thing that your manager or your board member has a relationship with the contractor, but it all has to be disclosed. Same thing with respect to the management company. If you hire a management company and one of your board members just happens to work for that management company, I would disclose it anyway, because if your board member is an employee there, they may not necessarily have a benefit from the association engaging that company, but still go ahead. You're never going to be, as I said, you're never going to be accused of over disclosing. And I would certainly make sure that you have a notation of that in the minutes. Let me move on. Okay, so question here about the minutes of every meeting need to be kept indefinitely or just annual meeting minutes, all your minutes, your board meeting minutes and your or any membership meeting minutes.
Hey, Lisa,
There's
there was a
questions here about,
question. Oh, sorry. Go ahead.
go ahead, no, go ahead.
Going to mention there was a question earlier that I typed an answer for. I didn't think it required an attorney's answer, which is why I did it, but I'm just going to mention it just in case. Cover my butt. Somebody was asking if they were a condo under 25 units, didn't have a website. How are the records to be preserved? And my answer was old school. You paper files, but you could also digitize files, save them as PDFs, and just store them digitally as a backup as well. Was that okay to answer the way I did?
Definitely, definitely. I mean, no one's going to argue with you for having paper. That's number one. Number two, when you have websites or you have digital files, it's really important that you have a way to ensure that future boards maintain can obtain possession or
Right.
access to those digital files. So even with websites, you want to make sure that the association is the owner of the website, and then whoever is the member of the board of directors of the association are entitled to the password to get into the back end of the website. If you have if you have cloud files, make sure that there's some way of knowing who's got who to obtain a new password or to communicate the password to new members of the board of directors so that those files are preserved. That's actually a
Okay.
very big issue.
Okay. And even if you don't are not required to have a website, I think it's a fantastic idea because it increases your office's productivity. You won't have people asking as many questions and contacting you as often if you educate people to go to the website. But anyway, back to you.
Well, especially when it comes to like architectural control concerns or maintenance concerns, or if they're calling to find out when the next board meeting is. I don't know how many people call for that purpose, but they do call to put in service requests. There
Yeah.
were bugs in my apartment, or the pest control that didn't arrive this month, or something along those lines. So yeah, having a website is always good for those purposes and just convenience purposes.
Yeah.
There's a question here. What's the Q&A sheet? The Q&A sheet is a very important document. It's a DBPR required form. It has either 10 or 11 questions on it. And once you fill it out once, you really won't need to modify it every year, except to the extent that you change the amount of the assessment. So it's really a disclosure document that says what kind of restrictions are applicable to ownership and use of the condominium unit, what kind of voting rights you have. Do you have to be a member of any other association, or is the association facing any lawsuits where the exposure is greater than $100,000? And what are my annual assessments, or what are my monthly or annual assessments, and how are they paid? Uh, so go ahead and make sure that if you don't have a Q&A sheet, go ahead and make sure that you uh, pull one together and then periodically update it when you update your rules and regulations, or when you amend your condominium documents. And there are a couple of questions here on the FinCEN and the reporting, the beneficial ownership reporting. That big lawsuit that was filed by the Small Business Administration, it was determined that the injunction is no longer in place, but with the administration now and the agency that's now in place, we don't see any requirement on the part of the associations to report the beneficial ownership. And I'm pretty confident. I mean, again, I'm not clairvoyant, but I'm pretty confident that those regulations will be modified to eliminate all reporting requirements. So uh, um, that's one thing that you don't have to worry about. And as far as your financial records, bank statements, deposit slips, how long do you retain them? You retain them for 7 years. Most of all your records you maintain for 7 years. The minutes are an exception. Of course, your condominium documents and amendments to condominium documents are exception. And then plans, permits, warranties for you new communities out there. Do something to make sure that you preserve and have a way to access those plans, permits, warranties, because those initial building plans become so crucial when it comes to future repairs. So if you can get them in a digital format and make sure that future board obtain them in digital format, that would be great. So we covered a lot today. I do want to thank you for participating. I know that there's there's 48 questions that I haven't been able to respond to yet, but please stay uh, in touch with us and join our mailing list, because we have these classes and other types of classes all the time, and every single class is different, even if it's the same topic or same label name of the class, because every presenter has a different take on how they want to present, and the questions are always different. So I encourage you to participate in all of them that you can, and I do want to thank you for attending today.